everyone, and welcome to InnoEnergy's Intellectual Property channel. We are the intellectual property team of InnoEnergy, and in this webinar series we will discuss 5 different types of intellectual property that everyone should know. And in the previous webinar, part 1, we already discussed trademarks and patents, and in this webinar, part 2, we will discuss copyrights, design rights, and trade secrets. And we will also briefly mention plant variety protection, database law, and semiconductor protection law. So let's start with copyrights. So how can copyrights help you protect your idea? Well, copyrights are intended for works that are related to literature, science, or art, and for works that are usually written down or drawn. And the works that are subject to copyrights are not only books, but also plays, musical works, other works of art such as statues, sculptures, architecture, photos, and movies. And in some cases, it also includes protection for geographical maps and computer programs. So copyrights might be a good option for you if you want to protect your software. And also technical drawings and databases can sometimes be protected under copyright law, although this depends on a specific situation and the country you're in. And copyright law also varies per country, but most laws state that copyrights provide the owner or the maker of the work or his or her successor with the exclusive right to publish the work and to multiply it. And in addition, the maker of the work has the right to oppose to anonymous publication and to oppose to publications under a different name than his or her. And you can also oppose to any change of the work, in particular mutilation of the work. And what is interesting about copyrights is that they remain enforceable even if the maker has transferred his author's rights. And this is especially important for architecture, where the architect can, for example, make objections to reconstruction of a building. This is not the case for patents. When someone completely transfers their patent rights to someone else, they lose all their claims to the invention, at least as discussed in the license agreement. And furthermore, with copyrights, there is no need for registration. This is also not the same as with patents and with trademarks. With copyrights, the author's rights come into being as soon as the work is created. And copyright protection lasts until 70 years after the death of the longest living maker. And in the case the maker of a work is unknown, the copyright lapses 70 years from the year following the first publication date. So you also have industrial design rights, which can be used to protect the look and feel of a product. You can, for example, protect the shape of a product or the look of the packaging. And design rights can also be used to protect graphical user interfaces or to protect drawings. So that might be interesting. And a design can, however, a design can only be protected if it relates to the appearance of a product. So excluded from protection is everything that is required to produce a technical effect. So for example, if a machine can only function when it's round, you cannot protect the round shape through industrial design right because it's a technical function. And the term for protection for a design right is 5 years from the date of registration. However, this term can be extended by 4 consecutive periods of 5 years to a maximum of 25 years. And a design right can be obtained by registering it with a design office or with an intellectual property office. So at last, we will talk a little bit about trade secrets as a form of intellectual property. Of course, trade secrets are only for those people who want to keep all their information a secret. And this is, for example, very opposite to patents, which are published publicly. And for a trade secret to be legally enforceable, it should be not generally known, and the information must have a commercial value because it's secret, and the information must also have been subject to reasonable steps under the circumstances by the person lawfully in control of the information to keep the information a secret. So if that is done, then you can keep a trade secret. And trade secrets are usually protected through the means of an agreement, such as a contract of employment or a confidentiality agreement like an NDA. However, you can also file secret information at certain offices, at certain intellectual property offices, or at the notary. So you have proof that that piece of information belonged to you from some moment onwards in time. And this may serve as evidence material when someone tries to steal your trade secret. And the benefit of a trade secret, depending on the extent of measures taken to keep it a secret, is that it is relatively cheap and easy when kept a secret, depending on what you did to keep it a secret. And there are no yearly fees that have to be paid, so that's very different than other types of intellectual property, which usually have registration fees and yearly fees to keep it in force. However, a downside is when confidentiality is broken, it is impossible to restore the confidentiality again, because what once has become publicly known will remain publicly known. So if your trade secret is out, you cannot protect it again because it is public. And furthermore, and in opposition to patents, if someone comes up with the same information on its own, there is no means of stopping them from using that information, as they came up with the information by themselves. So even if you have a trade secret, if someone else comes up with the same information as in your trade secret on its own, you cannot stop them from using that information. With the patent, on the other hand, if you have filed for patent protection and someone else is using your invention, even if they didn't know about your patent, you can stop them from using that information. So that might be something to consider. So there are some other forms of intellectual property which I will not discuss in detail, but you should keep them in mind. And the first one is plant variety protection, which is meant for the inventor of a new plant variety developed through long-lasting breeding. And another type of intellectual property is database law. For example, the protection of data collected in phone books. Such a form of protection can be very beneficial for companies who have developed a collection of data that has been systematically ordered, and that is accessible through electronic means or otherwise. So if you have collected some data and that is part of your company structure or commercial plan, you can protect it through database law. And at last, there is the right of semiconductor products or topographies, which relates to the protection of chips and microprocessors that are used in, for example, pocket calculators. So you can protect semiconductor products. So this was the end of our presentation. If you have any questions or would like to know more about any of these types of intellectual property from part 1 or 2, you can always contact us, and we would be more than happy to further advise you on which types of intellectual property protection would be beneficial for you or for your company. And furthermore, we'll be posting more informational videos online soon, so be sure to watch these by following our YouTube channel. You can find our videos in the intellectual property playlist. And you can contact any of us to our email addresses, which is frontname.lastname@innoenergy.com. And we also have a LinkedIn page, so yeah, you can visit us there. So thank you very much for your attention, and hopefully I will see you again at one of our other webinars. Thank you very much.